Good afternoon. Thank you for joining us. My name is Scott Zients. I lead the National Economic Development Incentives practice at the Voorhees Law Firm, and we're excited to have you join us for the 6th annual Voorhees Economic Development Incentives Conference. In just a few years, it's become the largest economic development incentives conference in the country, and we're really excited to have you. Last year, we hosted about 300 people in person. This year, we're making the best of it with this virtual platform. And next year, we're looking forward to seeing everyone in person and networking and just having each other's company again. The only thing we ask for you, we provide free continuing education. We're glad you're joining us. Please fill out the survey and give us any ideas you have for sessions next year. That's all I have. I'm going to turn it over to Kim and John. It's yours, Kim and John.
Scott, appreciate it. Glad to be here with everybody. I just want to do a quick introduction myself and allow my colleague Kim to introduce herself as well. I'm John Stock. I've been with Voorhees since 2017 in the Economic Development Incentives practice. Before that, I was Chief Legal Counsel for the Ohio Development Services Agency. And relevant to our topic today, before that, I spent 19 years as a litigator, 15 years with Jones Day, and then I left with 2 of my fellow partners to found our own firm, where I litigated for another 4 years before joining ODSA as the Chief Legal Counsel. So my experience crosses over between both litigation and incentives, and this topic's a nice mix of both of them for me. With that, I'll turn it over to Kim for introductions as well.
Thanks, John. Hello, everyone. I'm Kim Herlihy. My background is a lot simpler than John's. I've been here at the Voorhees firm for going on 23 years. I've been a partner in the litigation group for the past 15 years. And my practice spans all sorts of litigation, commercial contracts, real estate disputes, construction law, trademark and trade secret litigation, public records litigation, about which we'll talk a bit today, and many other pieces of litigation that touch on many of the issues we'll talk about today, particularly including litigation for or against public and state entities. So happy to be here with you today to talk about litigation in the incentives world.
So to start off on the substantive part of our presentation, I think it's worth making some note of the title. Some of you may recognize this quote. It's from the great football coach for the Green Bay Packers, Vince Lombardi. Winning isn't everything, it's the only thing. And he didn't mean that literally. He doesn't mean that you put everything behind winning, including ethics and things like that. He's talking about a mindset, an approach, a mentality to success, and being focused on the objective. And here I think it has a particular relevance for economic development incentive litigation. We have 3 types of economic development incentive litigation we're going to focus on. Those include contract disputes, tax exemption challenges, and public record requests. For at least a couple of these, it's very hard to get results that are split the baby type results. It's more often an all or nothing outcome. And so if you were to consider, for example, tax exemption challenges, there's very few answers where something's half exempt. If you consider public record requests, there's very few answers where something's half a public record. So for certain items that we're going to discuss today, the mentality expressed in the quote, I think does have some resonance and is an important thing to keep in mind. And with that, I'm going to take a look at the types of issues that make incentive litigation different. The first is you've got public dollars and public scrutiny that are going to come with the litigation. Typically, you've got press, you've got other interested parties taking a look at the monies being spent for incentives. And the bigger the project, the more scrutiny. And some of the projects are so large, everyone's heard about them. Everyone's heard of Amazon's HQ2 project. People all over the country have heard about the Foxconn project in Wisconsin. So the really large projects are going to attract attention. But even smaller projects may attract press attention because you're still dealing with public dollars. and it's going to receive greater scrutiny. Another issue that I think is really common in incentives litigation in many contexts is you're going to be dealing with home court advantage for the local community who provided the incentive. I know a lot of times when I talk to non-litigators, they roll their eyes a little bit at home court advantage because they think it's overstated. I guess what I'd say is you have to imagine that in smaller counties, there might only be 1 or 2 common pleas court judges. Everyone in those communities are going to know the judge, and the judge is going to know them and their families. And to give you a sense of what that's like, if you permit me one small story, when I was litigating in Butler County, Ohio, which is where I'm from, it's where I grew up, it's where my parents have lived their entire life, it's where several generations of my family have lived, and it's where my mom was active in politics. I went down there about 10 years ago for a motion hearing, and in front of the judge, I was appearing with opposing counsel there to argue, and the judge said the 5 worst words just about the opposing counsel could ever hear. She started the hearing by saying, "John, how's your mama doing?" That is not what you want to hear if you are on the other side of a case. And so that just gives you a little taste of what that's like. And so I would say on home court advantage, if you're thinking about having a swearing contest with people in the local community and that's your game plan for litigation, you may want to rethink that. Also, you've got all or nothing outcomes. I mentioned before the types of results with public records and with exemption challenges, but it's also possible in the breach of contract context. There was a case about 10 years ago called the town of Mammoth Lakes in California that had a development agreement that was sued on by a developer because the town was not timely and reasonably approving permits for a residential development. The reason they held back is they were getting pushback from the FAA on a local airport and didn't want to approve things, so they were holding up the development. The developer sued for anticipatory breach and won a $30 million judgment and attorney's fees in the case because the town wasn't actually approving the permits that they said they were going to approve in the development agreements. You can get runaway decisions sometimes even on incentive agreements, and that's an example one. And finally, the last issue is politics and policy changes. It's very often you'll have policy changes that'll change the direction of economic development litigation because the original position taken by a public body could change. Your issue could become more important, less important, or evolve over time based on the direction of public policy, and that can result in differences in the direction the litigation takes.
Yeah, John, to that point, I've fairly recently been involved in not an incentives litigation. Luckily, we have a lot of that yet, and hopefully we never will. But been involved in a highly public issue challenging a charter amendment, and particularly to your last point, John, that required an intense amount of kind of patience from our client's perspective. Our client was challenging the charter amendment that a city had adopted because not only were there policy changes involved, but there was intense political issues between the mayor and the city council. There were some city council members who were dismissed from their jobs during the course of the litigation, not related to the litigation, but certainly it affected the course of the litigation. There was intense press around those issues. And I would say one of the things that litigating in matters that involve that kind of public entity requires an intense amount of kind of patience, understanding, and outside the box thinking from time to time. So why don't we move on to the next slide? The first category of litigation we want to talk about are contract disputes. And why is that? Because incentives are commonly awarded through written agreements and therefore can lead to contract disputes. There are a few Ohio cases that provide some interesting lessons about contract disputes and what to expect or attempt to avoid in such disputes. One such case is the City of Westlake versus VWS, a case most recently decided by the 8th District Court of Appeal in Cuyahoga County. In this case, the City of Westlake sued for damages related to alleged breach of a CRA agreement. VMS was granted a tax exemption or a 50% tax abatement related to a new 100,000 square foot facility that it was leasing in the City of Westlake. And there were a number of covenants throughout the agreement, as you might, expect. One of the covenants was that VSM would increase its number of employees over 5 years. And its projection was that that would result in approximately $1 million of additional payroll over a 5-year period. The CRA agreement said that VSM would make its best efforts to ensure that 25% of the new employees were residents of Westlake. And importantly, one of the provisions of the CRA agreement, really the core provision at issue, was the following. Westlake grants VSM a tax exemption for real property improvements made to the project site pursuant to revised code, which shall be for 15 years at a tax exemption amount of 50%. As a condition of this tax exemption, VSM's income payroll tax must be 80% of the amount projected herein, or the abatement will be subject to amendment of the terms of this agreement, or Westlake may rescind. So what does that mean? Basically, that means that VSM, if they did not have an 80% achievement of their projected payroll tax, could be subject to clawback of the abatement. The agreement went on to say that no exemption would commence before December of 1998 or extend beyond December of 2013, so a 15-year period. VSM lived up to its obligation for 10 years. At the end of that 10 years, it closed the facility. And of course, the City of Westlake said, well, you violated our agreement. It was a 15-year agreement. VSM didn't see it that way. Westlake filed lawsuit, tried to recover about $360,000, and at the trial court level, the trial court said there is no provision for 15 years here. Sure, everybody thought it would be a 15-year agreement, and it said it wouldn't extend beyond 15 years, but there's no provision that specifically says this would be a 15-year requirement. So unfortunately for VSM at the trial court found against it. On appeal, however, the Court of Appeals said, we recognize that there's a lack of a specific provision requiring VSM to continue its operations for a 15-year period. However, the 15-year exemption period was fundamental to the agreement and the parties' performance. So at the end of the day, the appeals court said, I realize there's not a specific agreement for 15 years, but that was the fundamental essence of this agreement. And the trial court then, the trial court held VSM to that requirement and allowed Westlake to claw back the taxes that had been abated. What does this tell us? Be very careful about the provisions in our contracts. In this case, I suspect there was a dissent, but two of the judges on that appeals court panel perhaps deferred a little bit more to the city than they might in other cases. But it tells you to be very careful about the language that you employ and that another party tries to impose upon you in a written agreement. John, did you want to talk about the Hyde Park case?
Sure. Thanks, Kim. The companion case that covers this is Hyde Park Circle. Hyde Park is a case where the court actually enforced language strictly against a local community. in order to do that, what they did is they looked at a TIF agreement that the city had entered into, had a waterfall provision. And that waterfall provision, like many TIF agreements, is set up to create an order of who gets money out of the TIF fund. And like most, you've got the school district portion addressed first, you've got the developer portion addressed, and then you've got the city for the remainder. Pretty common setup. The city of Cincinnati uses a structure where they use a development agreement and a TIF service agreement in combination, and in that there's the waterfall. And here the city did something that pretty explicitly violated the agreement. They took money directly out of the TIF to cover amounts that were owed for the school district, the public school district, Cincinnati Public Schools. Court looked at that and said, you can't use that as a piggy bank to take money directly out of it. You have to pay back the developer for the amount that they would have received from the TIF fund to pay for the contractors who did work. And they awarded damages of $89,000 to the developer. The developer also brought a claim as a taxpayer in that case, claiming that public funds were mishandled. And the court also awarded the developer attorney's fees on their taxpayer claim. And so it's a interesting case because what happened is you've got an example of a strict enforcement against a local community based on the terms of the agreement versus the Westlake case where you have a court bending over backwards to look at intent to find in favor of the local community. So it's not, I don't think the message I would take is the courts will always favor the local community, but I do think the message is certainly important that how your agreement is drafted and whether you've anticipated issues is going to be a major contributor to whether you're going to be successful in the litigation. I also think there's an important similarity between the two cases that might be a little surprising. If you think about it from a fairness standpoint, in each case, the party who was engaged in the sharper business practices, maybe engaged in practices that were a little more aggressive and less reasonable, came out on the losing end, I think. So if you have, in the case of Westlake, you had a developer looking at trying to get out of a 15-year agreement. They were trying to use the silence in gray areas of the contract to get out of their obligation and not have any obligation going forward. And in Hyde Park Circle, you had a city looking to use the TIF fund as part of its general fund. And I think in each case, the court could be said to have looked to the more reasonable behavior and chosen the party based on who was engaged in the more reasonable behavior. At the end of the day, judges are human. They want to feel good about their decisions. And it's easy to see potentially how a judge in each of these cases, one for a local community and one against, could feel good about the outcome that they ruled on in these decisions. Tim, I'll throw it back to you for the next slide. I think you're still muted.
To John's point, hold on. That's my fault. Why is it not going? Sorry. As I was going to say, to John's point, maybe the number one tip for winning breach of contract cases should be to act reasonably, act on the up and up, because I agree that the lesson to be learned kind of wholly from those cases is judges want to do the right thing. They want to do what feels right. Some other more practical tips perhaps are to be clear in your contract terms, to read them carefully, to understand them, and to make sure they're in writing, to not rely on conversations you may have had before or after the contract was drafted. If it's before the contract was drafted, make sure it gets put into the contract, as most of these contracts will have integration clauses. If it's something agreed to after the contract was entered into, amend the contract or put a rider together or do something to memorialize changes and understandings that happen in the course of the relationship. Keep documentation of everything. Hold on to it from day one until long after the contract is over and done with. This is often the best thing for our clients, I have found, is to have a robust retention policy and to maintain documents and understand where they are and get your hands on them quickly. And if you are thinking you're in a position where you need to consider litigation, make sure you understand the risks and rewards of litigation, and that your attorney understands what's really truly important to you in that litigation. We've noted here the benefit, particularly in incentives cases, to front-loading the incentive, the receipt of the incentive. You want to avoid a situation where a clawback reaches back far enough to grasp any of that reward that you bargained for to begin with. So there's a benefit to drafting a contract as the recipient of an incentive to front-loading those incentives. And always monitor performance. And this goes on both sides, truly, monitor performance of your obligations and the opposing party's obligations under a contract. And as soon as you identify performance failures on your side, take some action, figure out what needs to be done, or at least consider what your options are then. Don't push them under the rug and wait. That's not going to help anybody. John, were there things that you wanted to add with respect to this slide?
Just a couple things. The first item is how you frame an issue can really matter. And you think about that a lot of times in litigation, where you frame issues in such a way to set them up to win. So for example, if you have a payment in a contract and it's important it's a reimbursement payment, you might define it as a reimbursement payment. And you think about doing that in litigation, but it doesn't have to start in litigation. It can start at the contract drafting stage. So once you pick your terms in such a way that you're already framing yourself for success, your payment in the contract is a reimbursement payment. In the litigation will be called a reimbursement payment. By the time you get to trial or in front of a judge or on briefs, that message is going to be loud and clear and consistent, and it's going to be hard for anyone in litigation to think of it any other way. So you can help frame the issue. The other one I'd mention is on the issue of keeping your evidence. I had a colleague tell me a story earlier this week about trying to find a school district notice on an incentive agreement where the company couldn't find it. The school district said they never received it. And this was years and years ago, but it resulted in the attorney digging through microfiche and doing everything else you can imagine to try and find the notice. That type of issue, when you don't keep your records, is what I jokingly refer to as a lawyer full employment plan, because all that does is guarantee you a chance to have a very long piece of litigation ahead where you have no way to resolve it on the law. You have probably a swearing contest, probably will go to trial, and you've got a long road ahead because documents weren't kept. So that, to me, is one of the things that can make a real difference in helping prepare for litigation. And with that, Kim, I'll turn it back to you.
Well, I think we're going to move on to a second area now of litigation we wanted to talk about, and that is tax exemption challenges. Unlike contract claims, these can come at you from all different directions. In a contract claim, typically the only party who's going to raise that claim against you is the other party you contracted with. In a tax exemption challenge, not so much. John, I think you want to talk a little bit more about who those stakeholders may be that can raise their hand.
Yeah, this is one of the problems with tax exemption challenges. Normally you have, in a contract, you're worried about your counterparty. Here, you're worried about next to everybody. When you're talking about everyone who owns taxable real property in the county or taxing district, or their spouse, you're talking about the local governing bodies like County Board of Commissioners, Township Board of Trustees, the legislative authority of a municipal corporation. And not on this list, but put a bullet next to the name is a school district, because they have one of the biggest incentives to fight tax exemptions of anyone, because if you look at the millage and how it's set up for real property taxes in the state, school districts are overwhelmingly the largest recipient of the millage for real property taxes. So they have a huge incentive to fight tax exemptions when they believe they're improperly granted. And as it turns out, fighting a tax exemption is pretty easy to start. You just need to file a complaint before December 31st of the tax year for which the exemption is being challenged. The complaint can be filed with the county auditor's office. And to emphasize how easy it is to do that, it's just a 2-page form. And it's a complaint against the continued exemption of real property from taxation. What is a little bit interesting about these complaints and how they're handled, and makes it different from other types of disputes, is where they go after this. When a decision's reached by either the county auditor's office or the tax commissioner on an issue related to an exemption, it can go to the Board of Tax Appeals. The Board of Tax Appeals is a professional board. They have 3 members, 2 of them attorneys. They're appointed by the governor. And it's really set up to help avoid some of these home court advantage issues, but also provide a degree of expertise on tax issues to promote consistency in decision-making. Board of Tax Appeals cases are tried to a magistrate, attorney examiner who writes up a decision, and then it goes to the Board of Tax Appeal board members for review. Most decisions come out 3-0. Occasionally they're a 2-1 decision, but it's not that common. I've had a chance to talk to one of my colleagues in the firm who has a great practice in this area, Nicholas Ray, who handles cases before the Board of Tax Appeals, and that would include not just in the case of incentives, but also the more common types of issues that you see with valuation challenges. He got to tell me some about the challenges right now with bringing cases before the Board of Tax Appeals during COVID. They have not had regular hearings since mid-March. I'm trying to implement a virtual hearing process. Both parties have to agree to it to sign a waiver. As it turns out, when both parties have to agree to sign a waiver, people who have an easily winnable case want to agree, and people who have a not so easily winnable case often don't want to agree. So it actually can gum up the works pretty significantly in terms of getting decisions through. In theory, cases before the Board of Tax Appeals should be faster in terms of getting to trial. It typically takes about 7 months on average to have a trial date. Parties can do their own hearing schedule, but they can get there in 7 months. Usually have 1 to 2 months of post hearing briefing by the parties. And then it could take anywhere from 6 months to a year to see a decision in the case. For cases that are decided by the Board of Tax Appeals, if they come through the tax commissioner, they can be appealed directly to the Ohio Supreme Court. Otherwise, they can go to the Ohio Court of Appeals. As you can imagine, cases before the Court of Appeals are not that common, so there is probably a fairly heavy amount of deference to the Board of Tax Appeals on tax issues from judges who don't often see cases involving tax issues at the Court of Appeals level. So with that, Kim, I'll turn it back to you for a second.
One of the things we wanted to talk about were a couple of the cases in Ohio from which we can gather some hints about how best to handle tax exemption challenges. The first one is a case decided by the Ohio Supreme Court, Princeton City School District Board of Education versus Zano, the tax commissioner, decided in 2002. I'm not going to go into a lot of detail on this case because I think you would find if you read it that a lot of it is a number of kind of desperate technical issues raised by the school district against an exemption decision, but it bears mention because it's a good example of just how far a Board of Education may go in this area. As John said, this is one of the entities that can challenge any type of tax exemption. And in this particular case, the school board, through a number of things up against the wall in an attempt to challenge a tax exemption, many of which would sound ridiculous to you. For instance, one of the challenges was that the application was technically deficient because it was signed by a deputy in the treasurer's office, as opposed to the treasurer herself, the Franklin or the Butler County treasurer. Those type of minutia permeate this decision, and ultimately, what the Supreme Court said was that the action of an administrative officer or board within the limits of jurisdiction conferred by law is presumed, in the absence of proof to the contrary, to be valid and to have been done in good faith and in the exercise of sound judgment. And I think that's the kind of deference that runs throughout this decision, and I think is something to keep in mind with these tax exemption challenges. A further point, on a larger point, the school board also attempted in another, I guess I would call it a Hail Mary, to raise a more substantive issue, but it was dealt a similar fate. Ultimately, the board argued that the TIF scheme adopted by the township deprived the school board of tax revenue under the Ohio Constitution. And to this kind of large challenge, but without much to back it, the court said, we decline to second guess the wisdom of the General Assembly in enacting TIF legislation. That's not our job. We're not going to do that. So this case kind of shows you both the tiny details being brushed aside really by the Supreme Court in favor of trusting the local township, and the broad questions of, does a TIF deprive a school board of a constitutional right, also being kind of overruled. And it's an interesting kind of broad spectrum of issues in a single case. John?
The other case that we have as an example of an exemption challenge is Fairfield Township Board of Trustees versus Testa. It's really sort of the opposite end of the spectrum from the Princeton decision, because this case involves a situation where the local community didn't do everything right and missed an important step in a significant way, not a small way. This case involves a church that received a exemption, as a public worship tax exemption that was available on land that had previously been in part of a TIF agreement. And it was set up to be a dispute over relative priorities of the exemption. And when you first read it, you think, well, this is going to be an issue of who filed the exemption and how it's treated under the statute, whether it was filed by the local community on their own or whether it was filed by the property owner or the local community with the property owner's blessing. But as it turns out, what happened with the Board of Trustees was a bigger miss. It was not simply a technical issue of the exemption challenge. They didn't file an application for an exemption. So when you start off by not filing an application for an exemption, they're behind the eight ball. And the argument they raised to the court was, well, look, we have a provision in our agreement that says this is a covenant running with the land. And because it's a covenant running with the land, it should still be an obligation for subsequent property owners. And the court looked at the issue and said, no, as it turns out, what you put in your contract doesn't trump Ohio TIF laws. We have a priority statute. We have rules about how this is handled. And we have requirements for filing exemption applications. And when you miss on something this fundamental, you don't get to write around it in your contract by making up your own rules. And so what the Fairfield Township case really is about is you can't contract around Ohio law. And that is sort of the opposite end of the spectrum with someone who's making technical arguments. Here's someone is making a big miss and saying, well, excuse it anyway, because our contract says we can. So the fact they went different directions, I think, is instructive. It's not a matter of courts being out to get people who make small mistakes. It's really a matter of looking to enforce the law where it's appropriate. This case, I should also note, came up in the context of a complaint that was filed by Fairfield Township for the tax exemption. So it came up exactly through the complaint process that we just discussed for cases that go to the Board of Tax Appeals. Kim, with that, I'll turn it back to you.
Let's move on to a few discussion points around tax exemption challenges. The first is the special problems that are presented by having your exemption subject to challenge, as John said, by such a broad range of complainants. As you know, in a situation like a class action, where there are a lot of people who can make the same kind of allegation against you or your company, you've got a vehicle for putting them all together, bringing them all into the same case, and having the judge deal with everybody in kind of one forum. You don't really have that here, where any citizen can bring a complaint, can file a challenge to a tax exemption issue. There's not a ready-made way to bring those all into the same location. And you can't control where they're going to do it or when they're going to do it or what they're going to say. So that's a challenge. And one that needs to be navigated if there's that tax exemption issue. We had a similar analogous issue in the charter amendment case I talked about earlier, where there were interveners who wanted to be part of the case, and there were other challenges to that going on in state court and in other venues that we had no way to pull it all together. And that does cause, it causes you to be flexible and nimble on a number of fronts and try to find ways, creative ways to work out an ultimate resolution. John, did you want to talk about curing or not curing?
Yeah, I do, and thanks for that comment on the challenges of having multiple potential complainants. It's a reminder that some of the settlement options that might be attractive in other circumstances are so much more elusive sometimes on tax exemption matters, particularly where the defect is public or known and other people could raise the same issue. For cure issues, sometimes you'll see technical mistakes made. You might think, for example, in a CRA agreement that after it's entered into, it's supposed to be sent to ODSA within 15 days. It's in the statute. And sometimes people might miss that requirement and think, well, I'm just going to go back, reapprove the agreement, and then restart the clock and send it correctly. And that may work if you've done it in a timely manner, but sometimes events overrun that because you're not supposed to enter into a CRA agreement after you've already started construction or remodeling. And so you could wind up in a situation where the idea of how to remediate to fix one problem causes a second problem unintended because you now have a time issue on the other end. And so that's the type of thing you have to be careful about when you remediate. Also, when you remediate, it tends to run up a red flag that something needed to get fixed. But the general rule for that is if you are able to remediate promptly and do the full steps without creating secondary problems, it's better to fix it and do it right than to leave a defect that someone could complain about later or use against you because it just sits there as a problem and it sticks out like a sore thumb relative to the requirements of the statute. And then the last point really is the same point we made before on compliance, which is you really want to keep your records of compliance. If you send a notice, keep a copy of it. If you transmitted a CRA agreement to ODSA or maybe an EZ agreement to ODSA or and the tax commissioner within the time period, keep the proof of transmission. Don't make it hard later on to show compliance and create issues where you really don't need them to exist. I think that can make a big difference and make things easier. So with that, I'm going to take a look at our public record requests. This is probably the most common area of incentive litigation. Public record requests are a frequent issue. Not all of these are high stakes. Some of them are very ordinary, but they can be high stakes. And the requests are significant. I mean, when I was chief legal counsel for ODSA, it felt like about one a day at least coming in on public record requests. Even though some were mundane, some required a significant amount of work. And being ready to deal with that was an important part of the job for a public office. And generally speaking, every public office has to make available copies of records to a requester within a reasonable period of time or make them available for inspection. There are, however, some important exemptions that relate to economic development incentives. You know, Jobs Ohio has one of the most important ones in that records created or received by Jobs Ohio have an exemption from being public records. Jobs Ohio itself is not a public office. And so it has a broad exemption. The only exception to that is very minor, and it deals with issues that are identified specifically in the service agreement between Jobs Ohio and ODSA. For all other purposes, Jobs Ohio is exempt from Ohio public record laws. Now, some of you may have heard records received by Jobs Ohio. I want to be clear about one thing. That does not mean a record that is already public in the hands of an agency can be sent to Jobs Ohio, and then you can spike the football and declare it is now immune from being a public record. That is not what that means. The statute thought of that. They anticipated that problem. That is not an option. But for records that are protected as exempt already, if they're in the hands of an agency, that exemption will continue. And so an example is the exemption enjoyed by the Ohio Development Services Agency. It has a exemption that's based on subject matter, and it targets material or data provided to ODSA that consists of trade secrets or commercial or financial information regarding a project. And so because it's subject matter based, one of the things you may see, for example, is when I was at ODSA, we produced documents that were redacted because things that fell into that subject matter could be excluded appropriately under the statute. The thing I would say to people interacting with ODSA, when you have a subject matter restriction, you want to make it as easy as possible on the agency to identify what those records are. Don't make them guess what your trade secret is. This is a public agency that knows their business. You know your business best as the company. Make it easy to identify what those records are. Kim, I'm going to turn it over to you for the trade secret discussion.
Sure. As John notes, or the slide notes, that trade secrets are an exemption to public records requests as well. There's a vast body of Ohio law as well as a statute about what a trade secret is. And a lot of cases will cite to 2000 Supreme Court case called Besser for the kind of the elements that you look at for whether something is a trade secret. They include the extent to which it's known outside the business, the extent to which it's known within the business, what precautions have been taken to protect the secrecy of that alleged trade secret, the savings or value in having that information as against your competitors, the amount of money or effort that was expended in developing or gaining the trade secret, and then the amount of time or expense that it would take someone else to develop that trade secret. The one that I wanted to kind of call out, and one that often is called out by courts, relates to the precautions that are taken to protect the secrecy of the alleged trade secret. There are many you can do to try to ensure that something maintains its trade secret status, but there's no way to 100% guarantee that you're going to do all the things right. Some of the things that we would recommend would include marking or stamping things with a trade secret or confidential stamp, locking it away in a way that's different from the way you lock everything else at your office or in your workspace. Not allowing employees to access trade secrets from personal devices, making sure when employees leave employment, they make sure you get those trade secrets back. They don't walk out with trade secrets, and that's your typical policy. There's a number of factors, and courts do look at these things. I've had a couple of cases that didn't arise in the public records request area necessarily, but it's the same test for whether something is a trade secret. Arose primarily in non-compete situations or other kind of trade litigation. One, for instance, related to machinery specifications for cryogenics equipment. Basically look like architectural drawings, but very detailed specifications that away at the business in the regular course of business, and were not needed by everyone in the business to review, but were left open on tables. And the court found that was an insufficient precaution. Even though they were stamped confidential, if they were not kept out of the view of employees who didn't need to see those, they weren't going to be stripped of their trade secret protection. I had a similar case that actually did involve architectural drawings that were submitted to a county zoning board without any kind of confidentiality agreement or arrangement, without any stamp on them, but were never divulged by that office to anybody else. Again, the court found that that was not sufficient to show us that those were secret documents. You needed to do something more. You needed to have a written agreement in place. You needed to reinforce those issues. You needed to get the documents back when the zoning board was done with them. There were things that you needed to do and you didn't do. So there is, as I said, we could talk about trade secrets for hours because there's just a lot of law on that's developed in all different kinds of cases, but it can often be an issue that comes up in public records requests. And you, as the party proposing that there's a trade secret at issue, you have the burden of proving that. This is not an exception that the requester of the public records has to disprove. You need to come in with real proof that you have met these factors, or that weighing these factors weighs in favor of trade secret, not just a conclusory claim that, oh yes, those are our trade secrets. It's a rather robust showing required. John, did you want to talk about infrastructure documents briefly?
I do. Thanks, Kim. The last item we have on the list here are infrastructure documents. The infrastructure documents are an item that was added as an exemption in Ohio in the wake of 9/11. Ohio, like many other states, thought about the fact that a lot of buildings, including private buildings, had sensitive documents about critical systems in public offices, like fire houses and other places like that would store records of buildings, and they wanted to come up with a way to protect them. An infrastructure record is any record that discloses the configuration of critical systems, including but not limited to communications, computers, electrical, water and plumbing systems, security codes, structure or structural configuration of the building. And what the exemption does is it allows these records to be filed with a statement indicating they're an infrastructure record, and exempts them for a period of 25 years if they're kept that long by the public office. These can sometimes be meaningful, and the different types of buildings have some of their most sensitive items on hand this way, and being able to use this exemption to protect them when you have to file the information with various public offices can be an asset to help keep that information confidential. There's a couple ways a person can bring a claim to enforce the public record laws. The first is, and this is the one that was more recently added to the code, is file a complaint with the Court of Claims. This is a means that was designed to be a quicker approach to resolve public record disputes. And it's one that more and more litigants are taking advantage of. The traditional means is filing a writ of mandamus. The writ of mandamus still retains an advantage, if not for speed. What it does retain the advantage on is the ability to get attorney's fees. So that makes it more attractive for certain types of circumstances where obtaining fees versus speed and resolution is a trade-off. The case below, Budison, is one that you may be familiar with indirectly, even if you're not familiar with the name. That case involves a request, a public record request filed by a news person for records related to Amazon's second headquarters, or HQ2. You may already know the outcome of this because you may be searching online as I'm saying this, but the HQ2 proposal is public that Cleveland filed. And the reason it's public is that this public record requested it. Cleveland made two arguments opposing it. First, they said it was a Jobs Ohio record, and the second is they said it was trade secret information. Court looked at the argument on the Jobs Ohio record and said, well, yes, Jobs Ohio records are protected, but the only record in the bid that was a Jobs Ohio record was one letter. What you actually did was you took the same bid and you took the information and reconfigured it, rearranged it, distributed the information, but you didn't actually have anything as an additional Jobs Ohio record. And so the way the court framed the issue, and this is the Court of Claims, it said, look, a Jobs Ohio record's protected, not Jobs Ohio information. If you're taking the same information and spreading it around in different ways into new records, you're not going to have that. And so the court only excluded the single Jobs Ohio record it identified, which was a letter, and then required the production of the bid documents that the city had prepared for HQ2. It caused a bit of a stir because those bid documents showed $3.5 billion of incentives, and that attracted no small amount of attention with a number of the people in the press related to the failure of transparency. And so these issues, back to the issue of public monies, public scrutiny, this is a great example of that, where it attracted the public scrutiny. The court also in Budison went through the same trade secret analysis that Kim talked about, looking at the steps and finding that the effort to protect that information was insufficient. Even though the city could have its own trade secret, it recognized that as a possibility. The court said that it hadn't satisfied the criteria for a trade secret with respect to this information, and no small measure because the information was distributed, made available, document, et cetera. So the case is an interesting one in terms of highlighting the fact that exemptions are not going to be construed broadly. It's your responsibility if you're a public office asserting the exemption to prove it and show that you're entitled to it. And as in Ohio and most states with public record acts, you're going to have the exemptions interpreted narrowly in favor of disclosure. This is an example of reaching that decision. Kim, I'll turn it over to you for the
Sure.
Next case.
Just briefly on the RR Ventures versus Columbiana County Port Authority case. There's a lot more to this case, but the 2 points that I think are most important in the interest of time are that this case appears to be the first time that the County Port Authority was found to be subject to public records requests. The court did find that the Columbiana County Port Authority was a quasi-public agency within and that RC 4582 to the Public Records Act. So documents that were in existence and requested from Columbiana County Port Authority needed to be provided unless an exemption were shown. And secondarily, this case touches upon attorney's fees for public records requests. A reward of attorney's fees is in the court's discretion if the court believes that the governmental entity subject to the public records request acts unreasonably, the court can award attorney's fees to the movant or the requester of those fees. In that case, the court held that that the Columbiana County Port Authority had acted reasonably. It was an unsettled legal issue and did not award attorney's fees, although there was a dissent and the dissenting judge would have awarded fees. So that is something certainly to keep in mind. Again, back to our theme of winning cases by acting reasonably. There's no need to have a fight over public records requests that are not significant issues, are not disclosing too much. Really, reasonableness govern whether you get tagged with an attorney's fees issue. Shall we move on, John? Here we go.
Makes sense. I appreciate that, Kim. The next time I have is just a couple highlighted discussion points for public record requests to think about. Pick your battles on public record request litigation. Pick, as Kim mentioned, pick things that are worth fighting over. A lot of the mistakes that you see in your own goals. One of my favorite ones from an example I'm aware of is I once saw a schematic involving items that were considered highly confidential disclosed to a landscaping office with the city, where they took the same schematic and put bushes around the outside of the building with all the important mechanicals, and then filed it in the office with the city, who then promptly put it on the website with all their other landscaping plans so everyone could see it and pull it up, where it's set for several months. Things like that have to do with knowing how your documents are going to be handled before they disclose, being careful how you use them. If you have a document that has something confidential and can avoid disclosing it at all, avoid disclosing it. Try to make your life easier by picking ways to disclose information that you can live with, or redacting documents where possible in advance so you can help protect that same information before you put it in the hands of a public office. You also should consider using NDAs. Can't be withheld from disclosure, NDAs before they're disclosed, and give you a chance to examine whether there are issues worth fighting, and give you a chance, if you need to raise issues in litigation, to do it in a timely fashion. Finally, strategic delay can be a huge asset. Sometimes the only thing you need to do with public records is delay to the announcement of a project. In fact, in some states, your protections that they have for confidentiality end once an agreement's signed. So if you can get to that point by delaying the disclosure. Finally, expect most agreements, certainly agreements with a public office, to be DA itself. I'm not talking about agreements with Jobs Ohio, but I am talking about agreements with agencies, townships, cities, counties, et cetera. So expect those to be public records.
We have.
And I'll turn it back to you.
Okay, thank you. Wanted to make sure. We have a couple slides here about trying to get the best deal on both sides. One on the side of companies, recipients of incentive awards for negotiating contracts, and one on the governmental side. And given close to our time, I'll just go through these quickly. Obviously, you want to have achievable metric commitments, something that you can, in fact, achieve. You want to narrowly define what a breach is so that you can avoid being in that territory. You want to look very closely at what the remedies are and how those might affect you, and try to limit them and narrow those as much as possible. Notice and cure provisions that can allow you to stay in compliance even when there might be a small issue, a small technical breach. Have a right to terminate, as we talked about earlier in the case I mentioned, the VSM case. Having a clear right to terminate often would be beneficial. And force majeure clauses that allow you, if you are unable for some issue well beyond your control to perform under a contract to have a potential out. Don, did you want to add anything on that before we kind of look at the other side of those?
Only that I imagine a lot of people out there had some opportunity to look at force majeure clauses all of a sudden this past year that they may not have paid much attention to, looking for magic words like pandemic and a few other issues. So I know that's been a hot button topic. So that's an example of one that's can be important, particularly in this time period.
Great. And then somewhat on the flip side, but things that might be particularly important to the governmental entity involved, having clearly defined metrics. I think that's helpful to everybody. But having robust reporting requirements, very important to know where things stand, to be kept in the know, and also strong remedies. The flip side, I suppose, of what I've just said, looking at clawback provisions in particular, ability to modify throughout the contract. Forum selection clause may be particularly important also for local governments, and attorney's fees, of course, something you always want to see and consider whether it's in your contract. And finally, indemnification issues. Given my practice, I really kind of thought of this from a tort perspective, making sure that there are indemnification provisions that indemnify you as the governmental entity who's simply providing rewards or monetary support to a particular project, and not boots on the ground on a particular project, providing you with some indemnification. I don't think that works on the flip side. I don't think you're permitted to under statute to indemnify on the prospectively yourself, but certainly an indemnification provision that protects you is an important one. I know I'm going through these quickly because and I know we're near our time, but John, is there anything else we should add for the good of the order?
The only thing I would add is avoid gray areas if possible. There are certain gray areas that come up, and some of those you can foresee. Like the one I've always mentioned, for example, is with the CRA agreement. I don't know what it means to start construction. Some case is going to find that out. I don't want to be that case. You don't want to have that case. So my thought is whenever possible, try to avoid those gray areas, and that's avoid the litigation in the first place. And with that, I think we've taken up our time.
We probably have. I just wanted to make a note to everyone. We've had a few questions come in while we've been talking. We appreciate those. What I think we will do is follow up separately with each of you, if that's all right, so we don't keep everybody on the line, but we will follow up with any of the questions that we've gotten, and we certainly appreciate your time and attention today.
I second that. It's been a pleasure to have a chance to present the information, and please don't hesitate to reach out to us if you have any follow-up questions.